right, the court is calling 2024 CR 0111624 State versus Jan Hawkins, AKA Jan Madura. And are you Miss Madura?
Yes, ma'am.
Counsel, off the record for a moment. So they have her AKA is Jan Madura, but that's her name, correct?
The case was originally submitted as Jan Hawkins.
Okay, but shouldn't Jan Hawkins be the AKA and not Jan Madura?
I think as long as they're both there, it's okay, is my understanding.
Okay, because all of the other paperwork doesn't have an AKA listed.
We don't have any objection to that, Judge.
All right, we're back on the record. State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving count one. We're proceeding on a lesser included of count two
And what are you proceeding on?
on a class A theft.
Did you understand the state is proceeding on the lesser included offense of theft, $750 up to $2,500? According to the plea, the state is proceeding on the lesser included offense under count two of theft, $750 to $2,500. They're waiving count one. They say that you've paid $1,077.01 to the Junior League of San Antonio. And I'm assuming there are no other outstanding restitutions.
There's one that we've got on there below the line, Your Honor. There was an insurance claim that was made by the complainant by Berkshire Hathaway. It's reflected at toward the bottom.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
Your Honor, if I may, we did make an amendment to the stipulations in concert for agreement with the ADA. We have marked out we're not saying that all the stipulations are true and correct. We have a controversy on the amount, the final amount. So
I think the issue, Judge, is that if you're intending to impose the restitution to Berkshire Hathaway and Visa, they're going to ask for a restitution hearing is the main issue here.
Well, I am going to ask to a restitution hearing.
Okay.
And the fact, these stipulation, you can't just cross out that you're not stipulating that the evidence is true and correct because you haven't stipulated which party you're saying is not correct. When you cross out the stipulations, then you're saying we're not stipulating to any of it. So you all will have to correct your paperwork.
Judge, if I may,
Mhm.
We've done this before. We are
Not
pleading
with
no.
me.
Actually, I have on one prior plea, on a case that was a family violence case, Judge, in this court. But we are pleading no contest, which means we don't necessarily agree, but we're not fighting about it, which is provided in the law for that purpose. We've also marked out judicial confession and changed it to no contest.
Oh, you can change all of that to no contest, but you can't change what you're stipulating to, because otherwise she's not even stipulating to the fact that she owed $1,000 to the Junior League.
Well, Judge, she doesn't have to stipulate to it. No, she's pleading no contest. And so
Okay.
that is the plea that's provided in order for people who disagree with what's being said to be able to move forward with a plea. I've never had a problem with that before. I've done it in this court.
No, I tell you what has been done. There has been with regards to the indictment that's a part of it where you say, I am not contesting anything, and you take out the judicial confession, but the evidence is the evidence that is presented. And then the court makes a ruling on whether or not that evidence is sufficient. But if you're saying we're not stipulating to the evidence that is being presented to the court, then she's not even stipulating to the fact that she's alleged to have committed a theft from the Junior League.
I think we've got a clean copy of the paperwork, Judge, that we can.
All right.
Judge,
swap out.
if I may, we can't stipulate to the amount. So we would have at the very
That's why
least.
you have it. Nobody ever stipulates to an amount. That's why you all have contested hearings and I make a decision on whether or not they owe it or not.
And Judge, and I know we're getting in sort of ahead of ourselves, but I'm asking for the court to not order restitution to the third parties. I don't think that that's appropriate.
Well,
They
that's
have-
where you present evidence and I make a decision, or you present some kind of law and I make a decision on whether or not that amount that is below the line, because it's not a part of your agreement, then I make a decision on whether or not that amount should be paid or any amount should be paid to Visa or Berkshire.
And Your Honor, it's what I'm requesting the court to do is to not order that so that can be handled in a civil court. They are set up for that. That's the way the normal course goes on these things. And it's going to be, we would need a forensic accountant to go through this. It's going to be a very long and arduous restitution.
I understand what everybody is saying. I want to let everybody know I'm internalizing what's being said. What I am telling the parties is this. If she's not stipulating to the evidence that's been presented by the state, that means she's not stipulating that she even committed a theft with the junior league. I don't know why she paid the amount to the junior league because she's not stipulating to that. Things that are below the line, that means that it's contested. That means that I'll hear evidence. I'll make a decision on whether or not restitution should be paid to Berkshire or Visa. That's something that I will hear. The only thing you're allowed to do, I don't contest, is when they have in the plea paperwork where it has the indictment on or about whatever. That's like on or about whatever I judicially admit. You can scratch that out and you put, I'm not contesting anything. But for the stipulated evidence, the evidence is what's being presented. Otherwise, if you're not stipulating to any of the evidence, then there's no plea.
Judge, we're willing to stipulate to everything except the final
Then you all
amount.
need to change your paper.
And Your Honor, I know, to press a point on this, it's my understanding, my belief that the law allows us to not stipulate to true and correct. The judge has the evidence and the judge can look at that and decide that they find those documents credible and find that they are true or
I can't do any of that if y'all are not stipulating to anything, then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea.
Okay, we'll redo the paperwork. Would you
All right.
accept if we just simply put on that we do
Oh,
not
y'all
stipulate
read-
to the final amount?
Y'all do the paperwork. And if y'all want to put in there that the final amount from Berkshire and Visa is contested, which to me I already said that, that's why it's below the line. If y'all want to do that, fine. But everything else, no.
And you understand that all the money was for the junior league, but they just filed an insurance claim and a Visa claim.
Here's the
They're
thing,
both
I haven't
false.
read any of the evidence, so I don't know what y'all are presenting because y'all haven't stipulated to anything. I don't know why there's an objection to outside the agreement. Everything that is outside your agreement is contested, and I'll hear evidence. This argument that you all are making on she doesn't owe to Berkshire, she doesn't owe to Visa, we haven't even got to that point yet because nobody stipulated to anything. And when things are below that line, that means that it's contested. That means I'll hear arguments. I'll hear whatever kind of law somebody wants to present me on whether or not you should be paying that under this cause number.
And Judge, the reason I am making this issue is because it says in the documents that higher amount. So we don't want to stipulate to that. So we'll change the document to say that and we'll reapproach.
Oh, y'all need to reprint that entire document out
We-
because that's been sworn to. She's been sworn to that specific document by the clerk. And if people start making changes to that document, it's no longer a sworn document.
We can do that, Judge.
Okay.
Thank you.
So yes, so everything needs to be reprinted and redone. Thank you.
Thank you.
All right, can I see the parties on Jan Madura? Oh, Ms. Madura, just give us a moment. You all have put on here that you're contesting the total amount owed for restitution. You're not, because you all agreed that she owed the amount to the junior league. Am I right? So
Right.
that's not contested.
Right.
So
Judge,
if I want to
may-
put that in there, you need to put specifically what you're contesting. If you're contesting the insurance company, then you should put the insurance company in there. Otherwise, you're saying you're contesting
Judge, may
your
I
league.
address? it?
Sure.
Because I'm the one doing this, not
Okay.
Chandler. So, Judge, what we're contesting is just the final total amount that are in the documents that are contained in State's Exhibit 1. And so that's what I'm trying to put on there, that we're contesting the total amount that they're saying is owed.
So you're contesting the amount that they're saying
We're
is
just
owed
saying
to
it's-
Berkshire Hathaway and Visa?
Yes, indirectly. I mean, in the documents, Judge, in the State's Exhibit, it has that she owes, that the total amount for the funds that were taken were 11,000 something, okay? We agreed to make a payment of the 1,077.01 upfront, but we have never, and we don't want to in the paperwork to stipulate that the 11,000 number that's in the State's Exhibit document is a correct number. We believe it's lower. So that's the only issue and Judge, and the reason why I want to have this in the paperwork is because if we're requesting that you not order a restitution hearing and let the third parties handle that on the civil side, where they can get accountants and they can really dig into that. And so if we stipulate to the true and correct nature of all of the state's exhibits, that includes that 11,000 number. And on the civil side, then there's nothing for them to, have accountants come in and
So this is what I'm telling you all. When you say you're not stipulating, you're stipulating to everything but the amount, you're including the amount to the junior league in that. If you want to put in there
okay, I can put in,
something that else to address that, you can put that in there. But when you all say you're not stipulating to any amount, then she's not even stipulating to the junior league amount.
okay, we can put in there to owe to third parties.
Well, the junior league is a third party.
Well, the junior league is the complainant. They're not a third party.
What I'm telling you is the parties are the
State
state
of
and the
Texas.
defense.
Right.
Well, your client, the state and your client. The junior league technically is a third party. So whatever is in there that you all are not stipulating to, which it appears to the court from your plea bargain agreement, the only thing you're not stipulating to is the amount to Berkshire and the amount to Visa.
Yes, Your Honor.
Is that correct?
Yes.
So
And
why
that's
is
below
it,
the line anyway.
so why is it hard to put in there? We are not stipulating to any amount owed to Berkshire or Visa. Why can't that be added if that's the total amount?
I can do that, Judge.
Okay. Thank you.
Thanks, Judge.
Do you want us to print this out again, or can I just change the language?
You'll have to write it in there and then have her resworn by the court. Court is calling 2024 CR 011624 State versus Jan Madura. And are you Miss Madura?
Yes.
All right. All right. With regards to the amount that's outside your agreement, we'll come back for a hearing. And at that time, I'll sentence. All right, Ms. Ferguson, I need a reset date. And this is just for restitution.
And Judge, are we going to have a full restitution hearing? If so, we're going to have to get a forensic accountant. I'm not an accountant, to go through all of the documents and bank records to prepare for that hearing. Your Honor, I would respectfully request if you would not order restitution or not make a decision and not have a hearing and let them handle that on the civil side in the civil courts.
Yeah, I'm not going to do that.
If I may respond briefly.
Yes.
Just the state's theory that amount be assessed as restitution is that is an amount the defendant received the benefit of. She can't keep.
I'm sorry.
She can't keep that benefit.
Okay. All right. We'll set it for a restitution hearing. Norm, I need a reset date for a restitution hearing.
And Judge,
You're out 45 days.
just to make it clear, we're not requesting that she keep anything. We are requesting that we get to the correct amount.
Okay. All right. We'll be back on December 11th. Once you sign the reset form, you're excused. And on that date, I will sentence. All right. Thank you. You're welcome.
You need anything else from me, Judge?
No, that's all.
Y'all have a great day.
All right, the court is calling 2025 CR 009909 State versus Nicholas Vaquera. Are you Mr. Vaquera?
Yes, ma'am.
All right, defense has filed a motion requesting the removal of GPS. State, are you opposed?
We are opposed, yes, Your Honor.
All right, defense, you may proceed.
Your Honor, the reason why we're filing this motion is my client's had the GPS on for well over a year. He's come to every court date. He has not had any issues with his GPS, with reporting, coming to court. We do apologize for him being a little tardy this morning, but he has come to many court dates and been on time. And for those reasons, we do ask that the GPS be removed. He has had no contact with complaining witness. They do not have contact. They do not have a relationship of any kind. And for those reasons, he is also trying to work multiple jobs, and in coordinating with GPS, it is very hard for him to coordinate those different jobs. So for those reasons, we are asking to remove GPS or at least place them on tracking only while we continue to fight this case.
State would object to removal and tracking. State would ask that GPS conditions remain as they are. Given the nature of the charge, the facts as they are alleged up to this point, Your Honor, as well as some history with this defendant on this particular type of behavior. I will say up front that the history I'm about to provide to the court all did lead to us dismissing the cases. However, it's still worthy to note that in October 2016, he had a prior sexual assault of a child case that I can't seem to find the reason for the dismissal in, I guess, because of the age of the case in the system. But that charge came about, as well as a month later, another sexual assault of a child and an online solicitation of a minor charge. That, again, for a reason we dismissed it, and I cannot find the reason for such dismissal within the system. Because of that conduct and the history with the system, we would ask that GPS conditions remain as they are, Your Honor.
All right, defense.
Your Honor, there's been no violation while he's been on GPS, and just to have him in his current condition is just to extend punishment beforehand. Case has not yet been litigated, is not ready to proceed at this moment. They're still waiting on a discovery matter. For those reasons, we are asking for at least tracking only. We would ask that it be removed. If he was committing violations, then this court would be aware of it, and we'd be addressing that violation right now. But he's been on GPS for over a year, and he's been complying with it. At this point, it's becoming punishment, and we're not yet at that point in this case.
All right, and what is the issue with discovery?
So when this offense occurred 2 years ago, police were unable to make contact with him initially. Till as of recent, DNA was obtained from the complainant, but not him. Now that he's regularly appearing in court, I made the detective aware of that, and they did a warrant for his buffalo swab that was just submitted to the lab on September the 30th. I called them yesterday. They hadn't got to it, but they put it at the top of the list, and I'm asking for a 30-day final discovery setting so we can get the results of that in. And they told me over the phone that 30 days should be more than enough time for them to finish testing of the defendant's buffalo swab.
All right, Ms. Ferguson, I need a 30-day reset for discovery and state at that time you need to be prepared to tender an offer.
Yes, I will, Your Honor.
Motion to remove the GPS is denied. All right, what date? All right, December 1st at that time, states you need to be prepared to tender an offer. And defense at that time, if the discovery is not complete with regards to the buccal swab and the DNA, you can file your motion and the court will reconsider.
Thank you, Judge. I
You're welcome.
appreciate that.
I woke up to a purring disgrace, a whiskered intruder invading my space, fur in my nose, tail in my eyes. This feline ambush took me by surprise. My cat sat on my face, what a bold embrace. No personal bubble, just fur in the place. She thinks she's a queen, I'm her comfy throne. My cat sat on my face and claimed it her own. I tried to breathe, but she wouldn't budge. Her paws of power held quite the grudge. I'm just her human, her soft little man. I feed her, I pet her, and this is my thanks for that. Oh, life with a diva, it's a constant shame. But today she chose my face. My cat sat on my face, what a bold embrace. No personal bubble, just fur in the place. She thinks she's a queen on her comfy throne. My cat sat on my face and claimed it her own. Struts around like she owns the air, knocks over glasses, sheds on the chair. But when I try to nap, she's on the attack with a fluffy butt parked square on my track.